Good morning, everyone. How are we? This is so exciting for us. This is our first employment law webinar in a couple of years, actually. I have known John for, I'd say probably about 5 years, and known Sian for, I would say, is it about
10.
10? My word. Okay, so both very trusted people in my world in terms of employment law. My name is Alyson Pellowe. I'm the business owner of People Vision. Don't worry, I won't waffle on too long. Just to say that People Vision has been in operation for about 15 years, been delivering HR and training support to businesses, very small micro businesses, some medium and some large scale businesses. Employment law is such an integral part to the advice that we give. Not that I'm by a long shot an expert, and that's why you won't hear too much from me. I haven't today in terms of the content, but I can help with the proceedings today, you know, maybe getting you, I have managed to set up a couple of polls that we can work with so that people can respond to those, and John and Sian are great experts in this field. So thank you so much for attending today. I'm going to hand over, maybe Sian, would you like to start by introducing yourself and then go to John?
Yes, good morning. My name is Sian Hughes. I'm an HR consultant with People Vision, and as I said, I've worked with Alyson for 10 years advising People Vision clients on HR and employment relations, employee law issues, and I have a master's degree in employment law, and I'm a member of the Employment Tribunal. Pass you over to John.
Good morning, everybody. John Hughes, partner doing employment law at Pennington's. Been here for more years than I care to name, but I'll just say it's more than 20. And we're going to spend today looking at the things to expect this year in terms of employment. Typically, I think of employment as an area that changes somewhat with the wind, but with political shifts, so there are big changes in employment law. And over the last few years, we have seen a huge amount of change in employment law. And before I started putting this set together, I was thinking that 2016 was a fairly quiet year, that there wasn't really anything particularly big on the horizon. Employment. I guess that's in a sense probably still true, but what I have realised when I was putting these notes together is actually there's quite a lot of change happening. It's just that each change in itself is relatively small. So without any further ado, what I'm going to do is go through in summary what we're going to pick up on. I've split it into two sections, the legislative changes, and I'm going to spend a very little bit of time on each of these because there's just so many things to get through. We're going to have a brief look at the Modern Slavery Act, touch on zero-hour contracts, gender pay reporting, the living wage, the national living wage, unpaid tribunal awards. There's been some recent comments in Parliament about those, apprenticeships, and then on the case law side, we're going to look at cases that discuss the role of HR in disciplinary proceedings, the question of when travel time counts as working time, the adjustment of holiday entitlement when your hours change, if you're going from part-time to full-time or the other way around, or just changing the number of hours that you do on a part-time basis. The recent and well-publicised case to do with monitoring of private emails. The vexed question of calculating holiday pay, this is sort of post-Bear Scotland stuff, we'll look at that. And finally a couple of cases on redundancy issues. So that's what we've got to go through on that. And hopefully during the course of this, Sian will interject with various questions, and obviously if any of you who are listening have any questions, please do use the box that Alyson has talked to you about to fill in a question, and Alyson will hopefully relay that to us at an appropriate moment. We'll try and answer it as we go along.
Yeah.
There will be a brief slot at the end for answers and questions as well. So,
can I just say,
sorry, Alyson.
Yeah, no, I was just going to say I don't know whether I know Sian said that she can see the chat box, but she can't see the question box. I've just sent a chat message to everybody saying, can you see this box? Could people just be testing that as John is chatting? could you either just go to the chat box and try and type things in, because normally this works brilliantly, so I'm not sure why today we haven't had any chat from anyone. So I'm not going to stop. Oh, no, can see some questions now. I've clicked another thing and people can see that. So people are using the questions box, not the chat box, which is absolutely fine. Thank you. So I'll just name a few names. Melissa, hello. Stephanie, Alicia, Jacqueline, Karen, Madonna, and so it goes on. Brilliant. I think I clicked the right button. So carry on, John.
Fine. Okay, no problems at all. So first of all, we're going to just touch very quickly on the Modern Slavery Act. This is possibly not necessarily an HR issue. What I have noticed talking to clients is that it's certainly an issue that nobody wants to really deal with, and is being passed from pillar to post. And inevitably, in most organisations, HR seem to be one of the people targeted at some point or other in that process to say, I think this is for you guys. Whether it is actually for you or for somebody else, it's useful for you to be aware briefly of what it does. It's an act that came into force on the 29th of October, and it relates to businesses that meet a certain threshold turnover, and that is a global turnover of more than 36 million, with an operation that takes place in the UK. So your turnover doesn't have to all be in the UK. Any amount of turnover in the UK, any operation that's happening in the UK, if your global turnover is 36 million, will bring you in the scope of the Act. And what the Act requires is that if you meet that threshold, you have to issue a statement every year, every financial year, starting with the first year that ends on or after the 31st of March this year. So most companies will either already be in the scope of they are going to have to prepare a statement very shortly, or their financial year will be starting shortly. The statement is that you have to set out what steps you have taken as a business during that relevant financial year to ensure that slavery and human trafficking has not taken place in any part of your business or in any of your supply chains. Now, there's no definition of a supply chain. The helpful guidance is it takes the normal, usual meaning. There is some guidance that the Home Office has issued. It is called Transparency in Supply Chains, etc., a practical guide, and it's 42 pages long. You can download it off the internet, and it has got some useful information in it, including some commentary about tips on what the statement should look like, how you should write it, and that sort of thing. But really the big question is, well, you produced a statement, but what are the sanctions? Well, actually, it's a pretty toothless bit of legislation, and what this reveals is that it's something that we all are panicking about, but possibly unnecessarily so. The requirement of the Act, excuse me, the requirement of the Act is not to eradicate slavery and human trafficking in your entire supply chain. Obviously, that's the ultimate goal of the legislation, but that is not the intention of your duty. Your duty is simply to produce a statement saying what you have done in the financial year. So you would be perfectly compliant with the Act to produce a statement that says we have done absolutely nothing, we have not looked, we haven't made any investigations, and we're just carrying on business as normal. That would be fully compliant. There would be no sanction applying on you. The sanction is really just pure peer pressure. The government is anticipating that a business is not going to want to issue a statement that says we've done nothing if all of its competitors are saying we've done this and we've done that. And that's really the limit of it. Obviously there are some sanctions if you don't produce a statement at all, but that's more in the case of warnings and so on. So it's really just a case of be aware that it has to be done. It needs to be signed at board level. But beyond that, there really isn't a lot to say on it. So I'm going to move straight on to the next section, which is perhaps a bit more interesting, and that's the question of 0 hours contracts. Now, just out of curiosity, while I'm talking about this, perhaps it might be good for people to type in if anybody actually uses 0 hour contracts in their business, so they could just say yes on the question box. It's actually one of those areas that not many people use them very often. Or where they are using them, it's usually out of employee choice, that the employees want 0 hours contracts because they like the flexibility. And I think there was quite an interesting CIPD survey. Sian, was it you that was telling me about this?
Yes, the CIPD did 2 reports, one in 2013 and one in 2015, on the use of 0 hours contracts, and they came to the conclusion, which was quite controversial, that on average people on 0 hours contracts are happier in work than those who are not on 0 hours contracts, who are on more traditional contracts, which goes counter to the sort of prevailing wind where 0 hours contracts are seen as evil. And they were challenged on their research methods, but they've been very robust in defending. So I imagine a lot of people on this call are CIPD members and may have read about this, but it's worth reading. It says information such as the vast majority of employers who use them treat people on 0 hours contracts as employees and give them the benefits as such. That also, maybe you might be surprised to hear that 0 hours contracts are much more common in the public and voluntary sector than they are in the private sector, because they are traditionally portrayed as the domain of evil, grasping private sector employers who are exploiting their employees, but that's not the case. My experience of 0 hours contracts, and I work in the catering industry, which uses them a lot, is that there's actually 2 separate labour markets: the market for people who want permanent fixed hours jobs and the market for people who want 0 hours. And I find it quite difficult to get people off 0 hours contracts onto permanent contracts because they like the flexibility, or they need it because of studying or childcare or other interests, you know, running their own business or that sort of thing. But it's, it's worth a read. It's very good report.
Yeah, that sort of use of them for the flexibility, particularly in terms of the family and the childcare side, I think is a key point which the government perhaps is missing, because it is, in my mind, part and parcel of the raft of sort of family-friendly rights and opportunities that exist these days. And I think it's good news that they weren't banned entirely. What was banned last year, and it came in May 2015 through the Small Business Enterprise and Employment Act, was the banning of exclusivity clauses, a clause which says you're not allowed to take up paid employment with anybody else. And I am entirely in favour of that concept. I don't think there is any need for an exclusivity clause. And certainly the clients that I've worked with, none of them either used them nor would they want to use them.
In terms of to do on that, sorry to butt in, I did find that a number of my clients, their 0 hours contracts were exactly the same as their permanent contracts, their fixed hours contracts, other than that they had the hours contract just says that you're not guaranteed any hours and it will vary according to the needs of the business. And we then had to rewrite the section on other employment
right, yes, because you have
staff.
Yeah.
We had a standard that you couldn't work for anybody else without our permission. We had to remove that,
yes.
Although we did say you can't work for the competitors because there's sort of business-specific knowledge that we didn't want people to breach. But that's something it's worth looking at if you do have people on 0 hours. Just make sure you haven't just got that clause by default.
Yes, no, that's a good point.
There's lots of people who've said they have. I mean, we've now got over 60 people on the call, and we've got about 10 people who've come in and said yes, they do have 0 hours. It would be interesting to see. I know John said about the sector, but it would be interesting to see if you want to add in again which sector you work in, to see where those 0 hours are or are not being used. Back over to you, John.
Yeah, thank you. So this banning on exclusivity came in last summer, but at the time it was fairly toothless, because other than making them unenforceable if they were in the contract, there wasn't any other protection on the employee. And it wasn't until this year the exclusivity terms in 0 hours contracts redress regulations, which actually were made in December last year but came into force on the 11th of January this year. That's really the first time we've actually seen any teeth to the exclusivity stuff. And what these regulations have brought in is the right for an employee to bring a claim for unfair dismissal if they're dismissed for failing to comply with an exclusivity clause that is in there. And there is no qualifying period, so you do not need 2 years service to bring such a claim. It's a straightaway claim. And there's also the right of a detriment claim, i.e. if you're subjected to a detriment for not complying with an exclusivity clause. So that's all I wanted to touch on with 0 hours. The next section is gender pay reporting. The Equality Act and the Small Business Enterprise and Employment Act created a regime. So Section 78 of the Equality Act gave the government a power to make regulations to require that employers with more than 250 employees should report on gender pay gap information. Section 147 of the Small Business Act said that mandatory reporting should be brought in within 12 months of the Act, the Small Business Act, coming into force. Well, the Small Business Act came into force on the 26th of March 2015. So, therefore, we can assume that the obligation to bring in mandatory gender pay reporting kicks in on the 26th of March 2016. The problem is that neither of those two sections, Section 78 and Section 147, have actually been themselves brought into force yet. So we have a mandatory date that actually isn't yet in force. There was consultation in the autumn last year. It closed in September. And we're still awaiting some of the clarification. So we don't know, we haven't seen any draft regulations as to exactly what the reporting is going to look like. And as yet, there is no indication of when they might come into force. However, because of the existence of those two sections, it is likely that it will suddenly come out and then be brought into force on the 26th of March. So we're probably anticipating a fairly short turnaround between the regulations being published in draft and then actually coming into force. There's lots of unknowns as to exactly what the reporting is going to look like, who's going to be required. There's a question mark about whether even the threshold of 250 is the right threshold. So there is a lot of uncertainty, but really I want to just flag it up and say watch this space because it's likely to come in the early part of this year.
John, I know there's already a requirement on employers in the public sector to do gender pay reporting. Does that give us any clue about what it might look like in terms of format?
Possibly, although the consultation suggested that it wasn't necessarily going to look exactly the same. But certainly it gives us some indication of the sort of things that might exist there, and that was within the consultation with those sort of questions. So yes, it might look a bit the same, but I don't think we can be sufficiently certain that it will. So the next section, and this section won't take that long, is the living wage, which suddenly came in the end of last year as an announcement. The National Minimum Wage Amendment Regulations bring it into force, and the first national living wage will be implemented on the 1st of April this year. I don't know whether that's a deliberate choice of date, April Fool's Day, but apparently not. To my mind, this is the national minimum wage by any other name. They've changed the date of coming into effect. Normally we have NMW changes in October. We're now going to have national living wage NLW changes in April each year, which coincides with the tax year a little bit more neatly. And obviously the living wage rate is set slightly higher than the NMW was going to have been set, with a target of getting to £9 an hour by 2020. The big debates that are going on at the moment, particularly in London, are that there has been a living wage foundation that's been pushing for living wage for a while now, and they set notional rates every year, and the rate for London for this year is already at £9.25, I think it is, or it's £9.15. It's already above the target rate that's been set for 2020. So there's a big question mark as to whether this is really going to have the impact that they would like it to have.
John, my understanding is that this living wage is for over 25s only. So for people who are under 25, will the NMW still exist?
That's my understanding, that yes, that the NMW will still be there, but there's a certain moral pressure to look at putting the living wage to everybody, as indeed there had been even in relation to the NMW, that the lower wage for younger people was always seen as a little bit of a moral debate.
But I do know that retailers do use those age. When you talk to people who work on checkouts in supermarkets, they're being paid, the under 21 rate, I find. So
yes,
that would still apply if they choose to do that, employers.
Yeah. Obviously, the impact of this new regulation is that it increases the wage rolls substantially in some instances, and at a much earlier date than people were perhaps budgeting and expecting. So for some industries and some businesses, it has thrown out their budget planning because they wouldn't have expected a wage rise hitting them in April. They would have expected it in October. It might be interesting actually just to find out how many people listening perceive that this will affect their business, that they've perhaps got people on a rate that, whether it's NMW or slightly above, but where this living wage is going to cause them to have to increase wages above that which they currently pay. Perhaps if anybody does, they can let us know whilst we're moving on.
And actually, just one other thing somebody said to me, you need to look out, if you're having problems trying to find how to answer things, you can go to, apparently there's a yellow stroke orange button that you can use. So try and press that if you're struggling to make connections online. So we've got some, yes, people are saying yes, definitely people are, whatever. Sorry, I missed your actual question. So that's from Nicola Ferraria. Hello, Nicola, how are you? And yes, it will affect us, says Sophie. Please keep those answers coming in. Yes, it does affect Ian, who is, it will affect his organisation. I should say, actually, I shouldn't actually announce where people, we do like to try and keep this confidential, so we won't actually mention your organisation if it's something that's, that's confidential. So people are saying, yes, we're already paying above the current living wage. We were about to take on apprentice, but even then they were above the current living wage. That says somebody else. So please do keep putting your answers in there. Back to you, John.
Okay, thank you. So the next section, unpaid tribunal awards. Now this sort of came upon us somewhat unexpectedly last week. The Section 150 of the Small Business Enterprise and Employment Act introduced a penalty system for businesses that failed to pay a tribunal award or a sum that they'd agreed to settle through a COT 3, through an ACAS settlement. But it didn't, that particular section wasn't brought into force. The Act itself obviously came into force, but that provision hadn't been brought into force. In the written answers to questions in the House of Commons last week on the 12th of January, from looking at Hansard, we can see that the government has announced that it intends to bring this into force in April. We don't have a date, but I would suspect it'll be the 1st of April. We haven't seen the regulation that's going to bring it into force yet. Obviously, we know what's going to come into force, but we haven't seen the in-force regulation. But I suspect it'll be the 1st of April. What Section 150 requires is that a business that hasn't paid its settlement will be given a warning notice and is given 28 days to pay. If within that 28-day period it hasn't paid, a penalty notice will be issued. The penalty is in the amount of 50% of the award, subject to a minimum of £100 and a maximum of £5,000. It's paid to the Secretary of State, and you have 28 days in which to pay that penalty. And if you pay within 14 days, it's reduced by 50%. Sounds remarkably like parking fines to me, and in reality it is a fine by any other name. So it's paid to the Secretary of State. Interest does accrue on the fine if it's not paid itself. What is unclear, however, from all of this is how the process is actually triggered at the outset. There certainly isn't likely to be any automatic issuing of a warning from the outset, but what we don't know is whether a claimant who hasn't received his money has to commence something in order to trigger that warning notice being sent out, or what. So we'll have to sort of wait and see how it works out in practice. But just be aware. I mean, hopefully none of you would receive an award to have to pay. But if you did, that you wouldn't be then not paying it. But just
I think the delegates might be surprised about the statistics I've seen. I haven't got the figure to hand, but what a large proportion of awards are never received by successful claimants. In my experience, that's partly because we quite often, when I sat on tribunal, hear cases where the employer doesn't bother turning up and often sends the tribunal a letter saying, we have gone into administration, but we still make an award, and then we say to the claimant, you'll go into the queue with all the other people who are owed money by this organisation. So that might explain the high proportion of awards are not paid, or in part explain it. I don't know what your experience is, John.
Yeah, I mean, most of the time...
You're representing reputable employers who would pay, I suppose.
Exactly. So, yeah, I mean, we did have one instance acting for an employer who hadn't paid, not because it didn't wish to pay, but in fact we were in the process of appealing the decision, and indeed the claimant was also appealing the decision. So both sides were appealing, and yet the claimant had managed to start a process to actually get enforcement of the award. And the first thing that the client knew was that the bailiffs had turned up threatening to remove valuable items. Now the client happened to be a hotel. The bailiffs turned up at around afternoon tea time and were threatening to take the paintings physically off the wall in front of all the people trying to have their afternoon tea if they didn't pay within the next 30 minutes. So not surprisingly...
So there's already a mechanism, yes, to...
So there is a mechanism.
Yeah.
It's not very well used, it's not very well known about, but it is there, and actually it's pretty effective. But we'll see. But other than that,
to advise people on what to do if we suspect. So often, if the employer hasn't turned up, we say this is what you do to try and get this award enforced. So
yeah. I mean, to round that particular story off, in the end, we did succeed on the appeal, and the money came back to us. But it was a bit of a palaver in the process. Fine. So the last section on legislative changes is the question of apprenticeships. There's a picture there of what probably most of us think of in terms of when we hear the word apprentice. We think of the old style tradesman who's brings on a young child and teaches them in the ways of their profession, and eventually the child takes over the practice. The modern apprenticeship concept goes far, far wider than that. And really the point that we're talking about in this particular instance is the introduction of the apprenticeship levy, which, much like the financial award for tribunals, it's a fine by any other, it's a tax, sorry, by any other name. They call it a levy, and there are specific reasons, I'm told, why the government won't call it a tax, because a tax suggests that the money received goes into general coffers to be used for everything, whereas a levy is allocated to a specific purpose. Interestingly, I had a meeting with one of the key civil servants in BIS who's responsible for dealing with these apprenticeships at the beginning of this week, a round table meeting, and one of the people there was a payroll company and an agency provider, sorry, not a payroll company, agency staff provider, and it was saying that from its perspective, it would be very helpful if the government would call it a tax, because that is a cost that can be passed on to the end user. Whereas if it's a levy, it isn't so clear that they can pass it on, so it affects their bottom line. Not something I'd previously thought about, but an interesting conundrum. The government isn't intending to call it a tax, so I suspect those that deal with providing agency staff will have to think about how this impacts on their overheads. But essentially, it's a levy that effectively applies to those with a wage bill of more than 3 million a year. I say effectively that because it's actually a 0.5% levy on the entire wage bill, but the government is giving a contribution of £15,000 or up to £15,000 to every business. So if your wage bill is less than 3 million, that contribution will effectively wipe out what the levy would be for you, so you pay zero. If you're over 3 million, then you'll start paying from that point onwards. The intention is to try and increase the number of apprenticeships. The government's set its election manifesto at 3 million apprentices, and they've got to get there. And they've also got to get there not in the traditional route of the 16 to 24-year-olds, because when you look at the demographics, there are not enough 16 to 24-year-olds in the pipeline to be able to achieve that goal, even if every single person became an apprentice. So they have to look at apprentices in a wider context.
Does that mean they're going to change the rules on apprenticeships? Because I know various employers complain the fact that they wanted to take on mature people under apprenticeship schemes but were prohibited from doing so.
Exactly, and that's one of the things that we're saying to them, that it has to change, and they acknowledge that it does have to change. What they're not really very clear about is what those changes are going to look like. The way in which the levy, the idea is that the levy is a tax that's paid by those employers, but they can then reclaim the money towards, and they then buy whatever training services they want for apprentices they take on, and they can get the money back again. That any money that those businesses that have paid the levy don't get back is then available to be given to small businesses who haven't actually paid a levy but still want to take on apprentices. And the philosophy was therefore that it enabled the funding gap to be met and for many more people to take on apprentices. It's all a bit catch-22, because what the government has said is that they want to encourage those who pay the levy to take on apprentices and therefore get the money back again, so that they're not actually losing out, they're just paying for their own apprentices effectively. But if that works in a perfect world, then there's no money for the SMEs, which is also what the purpose of this is, to try and get money into the hands of the SMEs. So I'm not quite sure how that really works. The amount of... Yeah. Sorry, go on.
I was going to say, talking to larger employers about this, I've talked to some larger employers who don't currently have apprenticeships, but in the industries where I thought they would do, I've said, I think it's worth you looking into it, because if you're going to have to pay the levy, you might as well have some apprentices, get some money back.
Yes, exactly, and certainly that's what the government wants them to do, because it helps increase the number of apprentices that are in the system. And of course the 3 million is only 3 million apprentices who start. There's no actual commitment by them to say that completing it. The mechanism by which you work out how much you get back is extremely complicated. It's all a little bit vague. The meeting I had this week was to try and get some clarity around what was being proposed. The BIS representative responded to most queries with, "That's an interesting question. We're still working on the details of that." And I have to say I came away from the meeting with probably less understanding of what they were intending than I'd gone into the meeting with. All that I did get out of it, which is helpful, is that a lot of the detail is being worked on at the moment, but they don't expect to be in a position to make any announcements until the autumn statement, which he also said was probably not until November, possibly even December this year. So we're not going to hear much in the details of what all this is going to look like for a while. All we do know is that the levy is going to be introduced with effect from April next year. So this is another of those sort of watch this space, but be aware of what's coming. So let's now turn on to some of the case law that's been going on.
John, just giving you a time check. My clock says 10:37. Just to give you a time check.
Yeah, no, that's fine. Thank you. So the first one we're going to look at is actually an EAT decision, which happened a few months ago, 4th of September, but I think it's an important case, and I just wanted to flag it up. Hopefully, you will have come across this case. It was a case in which the EAT were effectively reminding HR that whilst they definitely have a role to play in disciplinary proceedings, they need to be careful not to overstep that mark. The background of this was there was a manager who was handling a disciplinary. He was fairly inexperienced, and he was asking for assistance from HR to help him in preparing his report. Perhaps slightly unusually, he was the sort of investigating officer and the decision maker in this particular disciplinary. Rather than limiting its advice to the law or the procedure, or trying to ensure a consistency of sanction, what HR did in this case was actually effectively rewrite his decision and introduce their own views on the evidence. The manager initially had decided that this particular individual should be given a final warning, that he didn't think his behaviour amounted to gross misconduct, should be given a final warning. Put his report to HR, who basically rewrote it, and the final decision, allegedly in the manager's name, was that it was gross misconduct and a summary dismissal. The EAT said that that's stepping over too far. And in the case report, in the summary part, the judge says, a claimant facing disciplinary charges and a dismissal procedure is entitled to expect that the decision will be taken by the appropriate officer without having been lobbied by other parties as to the findings he should make as to culpability, and that he should be given notice of any changes in the case he has to meet so that he can deal with them. There are also some fairly scathing comments about what HR should do. It sometimes is used a little bit more draconiously than it should be this case. I think it's really just a reminder that you need to be careful if you're assisting somebody with a disciplinary not to try and impose your views on the outcome, but that you should simply ensure that they understand the range of responses that they need to think about and how they need to approach the question.
I wanted to just tip in with a personal experience of this where many years ago, before the days of written statements, witness statements in tribunal, my employer lost a tribunal case where the dismissing manager was asked, why did he dismiss this particular employee? And he said, because HR said I should. And we lost the case, and it's frustrating because actually there was a perfectly good case there for dismissal. One of the things that I now do with managers who are maybe in an adjournment before they dismiss as an HR consultant is I do a sort of a role play with them and say, if you were in an employment tribunal and I was the judge and asked you why did you decide to dismiss, you tell me why you decided to dismiss, why you considered it to be gross misconduct, why you ruled out other sanctions such as demotion or final written warning. And I find that's quite useful in any dismissal, but particularly dismissals that you think might be contentious and end at an employment tribunal, because you've already had that discussion with the dismissing manager in preparation for them being able to explain their decision to an employment judge.
Yes. Yeah, I think that's good advice. Thank you.
But as you people sometimes want to don't want to feel like they were the baddie who made the decision, and would rather say, well, HR told me, or use the royal we as the company have decided to dismiss you. But actually,
Yes.
employment law, you need to have a dismissing manager.
Absolutely, and that's certainly an amendment that I often make, is to try and encourage the clients to realise that whoever it is that's making that decision has to own that decision, and however uncomfortable it may be for them, they need to say, I made this decision, rather than, as you say, hide behind the we as a company have decided. So moving on to the next case, travel time. This was a European Court of Justice case. Again, it's a decision from September last year, but just wanted to pick up on it. It's not a major point, but it's a useful point for those of you who have a business where you've got employees who go off site to go and visit clients and that sort of thing, where that's habitually what they do. It used to be that your working time started from the moment you arrived at your first job, and then would be through the day until you finished on your last job. So travel time in between jobs in the middle of the day would obviously be part and parcel of your working time, but there were starts and ends of it at the beginning of the job and the end of the last job. What this case said is, no, that isn't quite right, because if you have no habitual place of work, the time it takes you to travel from home to your first place of work, and indeed from the end of your last piece of work back to home again, is also working time, and therefore obviously needs to be paid for and factored in. It's a straightforward point. I don't want to say any more on it. I just wanted to flag that up and as a reminder. Holiday entitlement. Now the bigger issue on holiday is holiday pay, and we'll come back to that one shortly. This point arguably is an obvious point, and in 99% of cases probably never really gives rise to an issue. But in this particular one, the facts did give rise to an issue. It was a European Court of Justice case again, and it was a decision from last year, this time in November. And it's what happens when the person's hours change and you recalculate their holiday. Well, in most instances, it's not a problem. But what happened in this particular case was that at the point at which the individual had changed her hours, and she was increasing the number of hours that she was working, she had taken a total of 12 days of leave, but in the pattern of work prior to change of hours, she was only working 1 day a week. So that 12-day amount of holiday equates to 12 weeks of leave. She then increased her hours for the remainder of the holiday year. And when she applied for another holiday, her manager said, sorry, you can't, you've used all your holiday. She said, well, no, I haven't, because I've obviously increased my hours, so I must have more holiday entitlement. And what they said, and the court upheld, was, well, no, because when you look at what you've had your 5.6 weeks allowance and some. So even though you've increased your hours, you don't get any extra holiday because you've used up your entire leave entitlement, albeit that you were accruing it at a faster rate on a daily basis. You were accruing it in weeks terms. And this is perhaps why it doesn't usually arise, because we don't generally think about holiday entitlement in terms of weeks. Weeks is what the Working Time Directive, the European legislation, talks about, and indeed the Working Time regulations do talk about it in weeks, but habitually we always think of it in days. We think of 20 days rather than 4 weeks. So it's just really a reminder that you need to take a little bit of care when calculating holiday entitlement, and you basically have to calculate it with reference to the specific days and weeks up to the point of change, and then assess how much proportionately of the entire year has been used, and then that amount of proportionate use is then carried over or it's exhausted for the second part. So it's a little bit more complicated calculation than perhaps we've assumed, although in practice it probably very rarely creates an issue, because I find, certainly in most instances when I've had to look at it, people take holiday at about the same rate as they accrue holiday. So there isn't usually a big mismatch between how much they've accrued and how much they've taken. So it's just really to be aware of that slight wrinkle on the calculation. So the next one, monitoring emails. Now this was a decision from last week, European Court of Justice, 12th of January. It made a lot of the newspapers, and there was lots of headline stories about employers can now snoop on your private emails. That's probably a slight exaggeration. Well, it is a slight exaggeration on what the case really said and the impact of the case, certainly in the UK. It was an argument about whether or not the individual's Article 8 rights to privacy were being infringed or not. And Article 8 has an entitlement to protection, but it is a proportionate right, and you balance your right to protection against another party's right to interfere with that protection. And what they basically said is, where you have an email account which is expressly set up for business purposes, it is not unreasonable for an employer to have access to that email account to check to make sure that you are performing business activity on it and not personal activity. And therefore, if they spot personal emails on that account, that would be indicative of the fact that you're not doing your work when you should be doing your work, and they might be able to rely on that. You still, from the UK's perspective, you still have to comply with other regulations like the Interception of Communications Act, the Data Protection Act, and so on. So you would still need a policy, and I don't think this case takes it any further than identifying that there is a personal email. It doesn't give you the right to open those personal emails, have a good route through them and read them and divulge the contents and so on. So it probably hasn't extended matters actually that far from what is already in place, which is that if you have a monitoring policy, you are entitled to look at an email account, and if you can see personal emails there, whilst you're not allowed to read the content, you're allowed to make reference to the fact that they're there and raise an issue with the employee if you need to. It's really just
in terms of policies, so if you've already got a policy that says that you should only use company emails for business use, and that we reserve the right to monitor to ensure compliance with that, that's sufficient?
Fine. That's sufficient, yes.
And I would say, as a consultant, if you don't have such a policy, I think it's a sensible policy to have, because you would be surprised how stupid some people are in terms of using work emails for non-work subjects. And I've occasionally got into debates with people who said, you've got no right to check my emails. And we say, well, yes, we have. And there's a whole load of emails to people that are clearly nothing to do with work during working hours. Which seems odd when everybody's got their own smartphones. Why on earth they decide to send emails to their mates during working hours on company emails, I do not understand. And I've also had cases of people sending very inappropriate material to their mates outside work, getting them from their mates outside work, clogging up the system with inappropriate videos, that sort of thing. And having a policy that says that we can monitor it is helpful.
Absolutely, and I think it's almost an essential policy these days. Even if you leave aside the misbehaving employee, if you've got an employee who is off sick and you need to be able to access their emails in their absence in order to keep matters progressing, technically, you don't have a right to access that if you don't have a policy which says we may be accessing your emails. So even just on a pure sort of business admin perspective, I think it's sensible to have that sort of policy, because you don't want to risk getting into problems if you come across emails that you shouldn't have done and you didn't technically have a right to access.
John, I'm just going to say it's 10:50, so you probably need about another 5 minutes maximum of presentation, and then that gives 5 minutes for Q&A. We do have one question already, so just as people as people are listening to this, if you want to put some comments, questions in, and some feedback, that would be great. It would be great to start collating that now so that I can hand that over. Sian, just also while John is speaking, I did whiz over a question. I don't know if you've seen that electronically that I sent to you. I don't know if you know the answer to it. Okay, don't worry. Don't worry, we'll bring it all up at the end. Okay, back to you, John.
Fine. Okay, no problems. So calculating holiday pay. We have the case of Locke and British Gas Trading, which has been floating around the courts for a while. Now, we're talking about a case which has now been heard in the EAT. The case was heard in December, the 8th and 9th of December, but we haven't yet had the judgment. In terms of what we're talking about the question of whether commission should be included within holiday pay. You'll all recall that we had the cases, Bear Scotland and Fulton and so on, in autumn last year, which dealt with overtime and whether or not overtime should be included within holiday pay. Locke is dealing with the question of whether commission should be counted as part of holiday pay. Traditionally it wasn't, because it was an outcome-based pay rather than a variation in the volume of work. And the legislation talks about where there's a variation in the volume of work and your pay varies accordingly, that you get that counts towards part of your pay. This case, Locke, did go up to the European Court of Justice, who basically said that you should include commission and similar payments as part of variable pay for this purpose. It then came back to the UK, and the Employment Tribunal, not surprisingly, adopted that approach, and in order to get round the legislative problem, it introduced words, it read words into the working time regulations in order to give effect to what the ECJ had said the directive required. Now that's what we call the purposive approach, and there's a huge amount of jurisprudence which talks about the entitlement of a national court to do that, to interpret its legislation, and it's obliged to interpret legislation purposively to give effect to the European law where possible. British Gas don't like the outcome of that, and they have appealed because they're saying that it's not appropriate for words to be read into the legislation because it creates uncertainty as to what the legislation in fact requires of private employers in the UK. We're still waiting the outcome of this case. It's unlikely to be different from the Employment Tribunal, but it's also likely to be appealed on again because it is an important jurisprudential point about to what extent our national legislation can be interfered with by virtue of what the European courts say and how the judges then have to interpret that. So this is not going to be the end of this particular issue for certain.
I'm conscious of time, but there's still debate about exactly what should be included, for example, voluntary overtime, and clients are asking me what to do on this. And my advice at the moment is, unless you're an employer where a very large proportion of somebody's pay is made up with these additional payments, then it's probably best to do nothing, but at least be aware of the possible cost. Do maybe an audit. I'm aware of one large employer where people regularly work large amounts of effectively compulsory overtime, and they have changed their policy to include that in their holiday pay. But otherwise, would you agree the best advice is to wait and see what happens with this case?
Absolutely. There are a number of different ways of dealing with it. They all have pros and cons, and probably the best one in some ways at the moment is an element of wait and see. There's a whole range, and certainly the first step is audit it and see what your issue is, and then think about it.
And am I right in thinking that the government has put a sort of a backstop on this, so that people won't be able to claim for sort of 20 years
Yes.
or 15
Exactly.
years? So.
Exactly. There's a maximum of going back 2 years. So you don't have the risk of historic claims going back to 1998 when the working time regs first came in, but you've got a backstop of 2 years. So, redundancy, there's a couple of cases, but very small. The first one is the US military base case, USA and Nolan. We're expecting this to go to the Court of Appeal sometime during the course of this year. And it's already been up to the Supreme Court on the question of whether or not the TELCRA, the Trade Union Labour Consolidation regulations, whether those apply to a military base. What the US government was trying to say is we're above the law. Supreme Court said no, you're not. The law does apply to you. And they're now going through a second set of litigation over the question of when the duty to consult for collective redundancy is triggered. What the regulations talk about is that you start having to consult when you are proposing to dismiss as redundant. And the big question is, when is that? And certainly in pragmatic terms, it's almost certainly earlier than you think, strictly speaking, but in practice is never adhered to, because most businesses wouldn't dream of talking to their employees before they're pretty certain something's going to happen, because you don't want to upset them. But the debate in this case is whether it's triggered when the employer is proposing to make operational decisions which might foreseeably lead to redundancies, or at a later point when they've made that decision and they're now proposing those consequential redundancies. It looks like it's probably going to be held legally to be the former of those. So as soon as you start making operational decisions where they might well lead to redundancies, that would be the trigger point. But I can't see people actually using that in practice. But it might be something that will then therefore be an appealable point in the future for employers, for employees that are unhappy. And the second case is the Woolworths case, Astor against Ethel Austin, and this is really the question of whether or not at one establishment is relevant for the purposes of Section 188 of TELCRA. The European Court of Justice has said yes, that does apply, and therefore what's now being looked at is whether or not each and every branch of Woolworths and of Ethel Austin was an establishment for this purpose or not. I can't see personally that the answer is going to be anything other than yes, each shop was a separate establishment.
I see this as good news for employers, making redundancies simpler.
Yes,
I've done
exactly.
some multi-site redundancies and trying to, aggregate all the different sites where different sorts of redundancy exercises might be taking place was quite a challenge.
Yes. Yeah, I mean, I think what will, the next question that will then arise is going to be where you've got a sort of split site establishment, and perhaps the sites are not absolutely adjacent but pretty close to one another.
And people move behind
exactly.
between sites would be a factor deciding.
Exactly. So that could cause complications, but at the moment that's just a prospective future claim to be. So that's really it in terms of things to expect this year. Just very briefly, just to pick up as we finish off, things that we already know about for further than 2016. The government has talked about increasing the scope of shared parental leave to working grandparents with effect from 2018, and we expect to see the consultation on that this year. We've got a bill currently working its way through Parliament for the increase of free childcare per week to 30 hours for eligible parents. That's for, I think it's 38 weeks in a year, so it's effectively for term time. But that's obviously to try and get more people able to work because their children are then being cared for. There's the British Bill of Rights, which, of course, in the manifesto there was a pledge to introduce a Bill of Rights to replace the Human Rights Act. Lots of noises about all of that. Somewhat less noise when, on the 2nd of December, Michael Gove announced that the plans for consultation about this that was supposed to have happened in December have been put on hold. Don't quite know what's happening with that one at the moment. It seems to have just been pushed quietly into the long grass, but I suspect it won't stay there. And then, of course, there's the trade union bill, which is also currently wending its way through Parliament, with the various limits being put on trade union activity, particularly in relation to the calling of strikes. There's a lot of detail in there, and I think given that these days trade unions don't affect that many businesses, I decided that it wasn't really something to cover in this talk in detail. Certainly, if there are people that are interested, we can do another talk on that topic in more detail, but just to be aware that that's working its way through. And that's it from me. So hopefully we've now got a couple of minutes. I'm conscious I've run slightly over, but hopefully we've still got people on the line for a couple of minutes with questions.
Alyson, I can't answer Ian's question, so I don't know if you could put it to John.
You pose it to John.
So yes, Ian's question is this webinar just relating to legislation in Great Britain? For example, the Equality Act does not apply in Northern Ireland. So I'm guessing from this that Ian is based or looks after some business in Northern Ireland. John, are you able to help about which parts of your presentation apply in Northern Ireland?
Yeah, effectively we are talking about Great Britain. Northern Ireland has its own separate legislation, so any of the legislative stuff does not technically cover Northern Ireland. What tends to happen there is that they introduce very similar or even identical legislation, but it is done separately. And I haven't looked to see whether there are identical bills or similar bills coming through in there or not. So I don't know offhand how much is effectively replicated in Northern Ireland, but in terms of these actual provisions, they don't apply in Northern Ireland. In terms of the case law, again, there is a separate body of case law in Northern Ireland, but both jurisdictions will look at the other, and the cases are very persuasive. So certainly, well, European Court of Justice cases would obviously apply in exactly the same way.
So holiday pay, those sort of things.
Exactly. The cases that are Court of Appeal, although technically there is a separate Northern Ireland Court of Appeal, it will, and the lower courts will look at the Great Britain Court of Appeal, England and Wales Court of Appeal, and take heed on what it is saying, and they will probably follow suit. So by implication, most of that will probably apply, but you have to bear in mind there is slightly different legislation in Northern Ireland.
And Ian's asked about the apprenticeship levy in Northern Ireland again. I'm not sure.
That specifically, I don't know offhand. No, we can check, but I don't know offhand whether that's. I suspect it possibly doesn't, because there's a slightly separate tax regime in Northern Ireland.
Yes, that would be my guess.
We have another question from Louise. Hello, Louise. Long time no see. So nice to have all these lovely friends and colleagues and clients from my 15 years in business. So you see, I just keep all your email addresses. You don't go anywhere. So is there any evidence of much take-up of shared parental leave?
Almost none.
Tiny take-up. The only questions I've had from people who turned out not to be entitled, so a male employee whose wife was pregnant but she wasn't working, and so he thought he could get some shared parental leave, but I explained there was nothing to share because his wife wasn't in receipt of any, wasn't entitled to any maternity pay or leave, and that's the only time I've been asked the question.
Yeah, I mean, I think it's what's revealing is that there was a very, very low take-up of paternity leave, and I appreciate that the pay is slightly different structure, but given that there wasn't much willingness to do that, it's not surprising. Exactly, it's not surprising that not many people are doing the shared parental leave either.
I used to call additional paternity leave shared parental leave light. It was the same thing, really.
Yeah, it was.
The time it's most likely to happen is when the mother earns more than the father, and so the mother goes back to work early, and the father then becomes the main carer. Yes, I can see it happening in those situations. Of a month here, a month there, which in theory they can do, although also an employer can refuse that non-consecutive shared parental leave on business grounds.
I suspect the other aspect is I'm not sure how many people really fully understand what it is and what options they've got. There are now so many different variations of what we call family-friendly rights that you could easily be unaware of some of them. I mean, shared parental leave is completely different to parental leave. They're not comparable at all. As you say, it's actually shared parental leave is closer to additional paternity leave than it is to parental leave. We've sort of run out of terminology that distinguishes it from the next one.
For that reason, I haven't spent a lot of time writing complicated policies on shared parental leave, because I found that it ended up being about a 10-page policy that was unlikely to be used in most of my small employers. So I've said to people to tell people, if they're interested, come and talk to HR and we'll tell them more.
Yes.
Rather than issuing a very complicated procedure, writing loads of standard letters, etc.
Yeah, I must admit, I'm not a fan of policies that effectively just replicate what is a statutory right.
I say just go to the government website, it's all there.
Exactly, and it also means that it's up to date, because if there is some change, you don't have to keep rechanging.
Well, the rate's going to change every year, so.
Yeah, exactly.
Guys, that's been brilliant. I don't have any more. There was a thank you from Ian on answering his Northern Ireland questions.
Or not, unfortunately.
Well, we're only limited.
We tried.
But listen, thank you so much, Sian and John. That was absolutely brilliant. And I think everybody's really enjoyed that. I've certainly had some lovely feedback on the questions thing. So any further feedback would be great. I'm just going to finish the session with one. We're just interested to know what maybe there's three things that might be bothering you. It might be something else. This is more about having an opportunity to use the polling. And it's just the last thing to do is maybe people would just answer that. Hopefully you can see that come up on your screens now. Obviously we could have put numerous amounts of
settlement agreements, they're called, Alyson. Sorry to correct you.
Oh, you see, I'm a bit out of the loop. This is why I use you, Sian. So we're just still waiting. We've got 39% of you voted, and so 46%. And yeah, any comments? So we've just got, thank you for the webinar. It's been really useful and time well spent. Thank you, John and Sian. Great session. And thank you for not cutting it short. Joanna says, really interesting. Thank you very much. Sheena says, a useful overview, thank you, fantastic webinar, and so it goes on. So that's really fantastic. So we've still only got 68%, but I'm gonna close that. Oh no, and then share. Let's see. So there you go. Those are the answers from that poll. We will be emailing all of you to see whether there's some specific sessions that you'd like in more detail. But if you want to just give me some ideas of sessions, please do put it on the questions box right now, as we'd love to get some early ideas. And if anyone would like to be a speaker on one of these sessions, if you're working specifically, I'm not looking really for the freelance people, but anyone who was an employment lawyer who's been listening in, or anyone who's in industry. So one of my clients, Nicola, I bet you'd be really good at it. I know you're still online there. Or Jan, anyone who would be interested in being one of the panel members. Honestly, the technology is dead easy when we get it right. It would be great to get a portfolio. We're building a whole year of events. So yeah, anyone who'd like to be interested, please make contact. I'm going to hand to Sian, who can then hand to John to close. So thank you very much from me, Alyson Pellowe. Over to Sian.
Well, thank you very much. Thank you for your comments and questions. Useful, as Alyson said, it'd be great if other people can contribute. So if people who've got practical knowledge of some of the things we covered, like apprenticeships, that sort of thing, that would be very interesting subject to cover in future webinars. And hopefully we'll hear from you soon. And yes, do get in touch if there's anything you want us to do future webinars on, or any advice that you want. And I'll pass you to John to close.
Well, thank you, Sian, for your helpful comments and questions and interjections. Alyson, thank you for the opportunity to speak. And as both Alyson and Sian have said, if you have any follow-up queries, by all means get in contact with us. If you've got my contact details, feel free to contact me direct. If not, I'm sure Alyson can pass queries on to me if she can't deal with them. But it's been a very interesting opportunity for me to just remind myself what is happening in the next year. And as I said at the beginning, I surprised myself in realising there's actually more coming than I was initially thinking there was. But thank you, and have a good day, everybody.
Brilliant. John, when I send out, what I'll do is for everybody that's attending the call today, I will upload this onto our website, and they'll all get a link so that they can, I'm sure they'll all be dying to listen to it all again, you know, maybe 3 times, wouldn't you? No, but they might want to share it with some of their colleagues, which is absolutely fine. But I will, I'll make sure that your email address is visible to all the people who attended, so that they, if they wanted to make contact or indeed use your fantastic services, I can recommend Pennington's, very good law firm, and you are a nationwide organisation, aren't you?
We are, yes, yep, and international in the sense that
global.
we have connections with lots and lots of different law firms. So I chair a group of about 600 employment lawyers globally.
Oh, brilliant. All right, so John and Sian, I'm going to close this. If anyone's got any further comments, please do pop them on the questions. Thank you so much, and have a great day.
Thanks, everybody. Bye-bye.
Goodbye.